Good afternoon or good morning, everyone, and welcome to our webinar, Preparing for Canada's New Consumer Privacy Protection Act. My name is David Fraser. I'm a privacy lawyer here with McInnes Cooper, where I regularly advise private and public sector clients to implement compliance for Canadian privacy legislation. I'm here with my colleague and partner, Sarah Anderson Dykema. She's a certified information privacy professional for Canada through the IAPP and an integral member of our privacy and technology law group here at McInnes Cooper. So first of all, we're going to have a polling question to ask everybody for your organization. How does your organization handle personal information? You'll be able to watch your screen to answer, and then the answers will be presented momentarily. Let's see what the response is. One second. Just enlarge that for me so I can see it a little bit better. So thank you for that. So here we are talking about Bill C-27, which the government introduced, Bill C-27 on June 16, 2022, so not that long ago, and they introduced it just on the eve of Parliament rising for the summer in order to take their summer break. So it's currently sitting there at first reading and will not be touched by parliamentarians until Parliament resumes in the middle of September. So that gives us a little bit of a leeway and an opportunity to take in what Bill C-27 says, to digest it and anticipate it, and for some organizations to think about what representations they might be planning to make to the parliamentary committee that it's referred to in the fall. And so this particular bill is very similar to Bill C-11, which was tabled in 2019. Which actually had the same title. The bill itself was called the Digital Charter Implementation Act of 2019. Bill C-27 is actually called the Digital Charter Implementation Act of 2022. Bill C-11 never progressed in Parliament, and ultimately it died on the order paper when the last election was called. We anticipate, but I guess nobody knows for sure other than civil servants in the minister's office and the minister himself, to what extent this is going to get boosted through Parliament. But the digital charter was part of their election campaign, the government's election campaign most recently. Also, that could be said, the digital charter was part of the previous election campaign. So it'll be interesting to see what sort of boost it gets through Parliament. Hopefully it is not fast-tracked, and there will be an opportunity for organizations and individuals to make representations to the privacy, to the committee that's going to review it, because there are some things that at least I think, and I expect others imagine, could be improved or at least clarified. So Bill C-27, it in fact packs a little bit of a punch because it has 3 bills in it. One thing that's different is the third bill that was not in C-11 in 2019. So the first part of C-27 is the Consumer Privacy Protection Act, which is the main privacy law that will replace the Personal Information Protection and Electronic Documents Act. The second part of Bill C-27 is the Personal Information and Data Protection Tribunal Act, which will create a whole new tribunal to replace the current role of the federal court under PIPEDA and enable this new penalty regime that we're going to talk about. That was there in C-11 in 2019 as well. Part 3 is what's really new, and we're not going to talk about it too much right now, but I expect we will have further things to say about it later, which is the Artificial Intelligence and Data Act, which regulates the use of artificial intelligence with respect to organizations that are engaged in interprovincial or international trade. And how that will be implemented and how that will actually be rolled out, so much of it depends upon the regulations that have not been published or at least have not even been discussed. So it's difficult to say exactly what it's going to look like. It's interesting and anomalous compared to what is the Digital Charter Implementation Act Parts 1 and 2, because it does not use the tribunal, it does not use the privacy commissioner. It's a completely different animal of regulatory regime compared to what it is that we've seen in the rest of it. So let's do one other quick polling question. Is your organization federally or provincially regulated? And you can watch your screen to answer this question. Great. Yes, the majority are provincially regulated, and the answer to this question is actually has some significant consequences for organizations. Similar to PIPEDA, So one of the things that the former privacy commissioner advocated for was to build into PIPEDA a human rights approach to privacy, or to a PIPEDA replacement. When C11 was introduced in 2019, the then Privacy Commissioner of Canada made a number of representations looking for a human rights-based approach, and that was not adopted in the CPPA. One thing also related to that, and I think one of the reasons why that was not done is because of just the constitutional nature of Canada and the division of powers. So the federal government actually, and the federal parliament actually has limited jurisdiction. That's why PIPEDA, the existing statute that's been in place since 2001, only applies to the collection, use, and disclosure of personal information in the course of commercial activities, using the general trade and commerce power in the Constitution. And it specifically applies to federally regulated workplaces. So the collection, use, and disclosure of personal information about employees, prospective employees, and former employees of federal works undertakings and businesses. And so one thing that's interesting and remarkable, and I suppose should have been predictable, is that the proposed CPPA follows that almost exactly, follows the model from PIPEDA. So the CPPA will apply to the collection, use, and disclosure of personal information in the course of commercial activity by organizations, almost identically the same test as exists under PIPEDA. And it also applies to employee information, but only for federal works undertakings and businesses. Again, that's virtually identical to the situation in PIPEDA. So if you're not a federally regulated organization, you should not have to worry about PIPEDA applying to your employee information or applying to the workplace, except there's a little bit of uncertainty or ambiguity about interprovincial transfers that my colleague Sarah is going to talk about in due course. So Sarah, we'll talk about the main new obligations within the legislation.
Yes, thank you, David. And hello, everybody. Thank you for being here today. So I'm going to outline some of the key new obligations under this proposed new law. So first is the obligation for all organizations to which the law applies, which David just talked about, to have what they call a privacy management program. So in other words, this will be an obligation for any organization currently subject to PIPEDA, but also organizations that collect, use, or disclose personal information internationally or interprovincially. So organizations need to implement and maintain a privacy management program that includes the policies, practices, and procedures required to comply with the Act. And in the particular policies, practices, and procedures, this program must cover the protection of personal information, how requests for information and complaints are received and dealt with, the training and information provided to the organization's staff about its policies, practices, and procedures, and also the development of materials to explain these practices and procedures. And not only that, organizations will also have to provide all the details about this privacy management program to the Privacy Commissioner on request. And after reviewing it, the Commissioner can provide guidance on it or recommend corrective measures to be taken by the organization. So there is another thing introduced, and that is the concept of codes of practice. So that's reintroduced from C11 into the CPPA. So notwithstanding this requirement for a privacy management program, the CPPA allows organizations to establish a code and internal certification programs for complying with the CCPA, which is then approved by the Privacy Commissioner. And then once approved, this code will effectively establish the organization's legal compliance obligations. And in essence, this is a means of encouraging voluntary practices that favor privacy protection. But note, compliance with these requirements of a code doesn't relieve an organization of its overall obligations under the new law. So the next new obligation has to deal with consent and the documentation of consent. So while under PIPEDA, there is an obligation for organizations to record and document the purposes for which personal information is collected, the new CPPA goes beyond this and actually requires an organization to identify and record each of the purposes for which it collects, uses, or discloses personal information. And this must be done at or before the time of collection. So in addition, Section 15 of C27 sets out in detail what is required for consent to be valid. So essentially, it requires not only identifying the purposes for which the personal information will be used, but also communicating in plain language how the information will be collected, the reasonably foreseeable consequences of the proposed collection, use, and disclosure, and also what type of information will be disclosed and to whom. So the legal framework of the CPPA remains designed around a requirement that consent be obtained for the collection, use, and disclosure of personal information, unless one of the listed exceptions to consent applies. And these exceptions include transfers to service providers, use of personal information for internal research, analysis, and development, provided that the information is de-identified, and certain business activities. So under the CPPA, an organization can collect personal information without knowledge or consent of the individual if the collection or use is made for the purposes of a business activity. But before they do that, the organization must make sure that a reasonable person would expect the collection or use for such an activity. And second, that the personal information is not collected or used for the purpose of influencing the individual's behavior or decisions. So what counts as a business activity? That includes an activity that's necessary to provide a product or service that the individual has requested, or for the organization's information system or network security, or for the safety of a product or service that the organization provides, and any other prescribed activity. And of course, the regulations are not yet drafted, so we don't know what that might look like. There is also the new exception to the requirement of obtaining consent of legitimate interest. Now, this requires an organization to document any possible adverse effects on the individual, to mitigate them, and then finally weigh whether the legitimate interest outweighs any adverse effects on the individual. However, it's unclear what or how adverse effects will be measured. And importantly, organizations that rely on this legitimate interest exception will be required to complete a privacy impact assessment and provide copies of it to the commissioner on demand. And as with the business activities exception, an organization relying on the legitimate interest exception must also ensure that a reasonable person would expect the collection or use for such an activity, and that the personal information is not collected or used for the purpose of influencing the individual's behavior or decisions. And also of note with respect to consent, which we'll talk about a little bit later, is that the CPPA allows an individual to withdraw their consent subject to certain limitations that currently exist in PIPEDA. And next, we're going to have another polling question. So do you collect, use, or disclose personal information other than employee information across provincial or national borders? Okay, so overwhelmingly, the answer is yes. So now let's look at another one of the kind of new obligations, which is the global application of the law. So as is the case under PIPEDA, the CPPA will apply to the collection, use, and disclosure of personal information in the course of commercial activity and to employee information of federally regulated organizations, as David explained earlier. So however, the Bill C-27 version of the CPPA also applies to all personal information an organization collects, uses, or discloses interprovincially or internationally. So in the past, the Federal Privacy Commissioner asserted that this was implied under PIPEDA, but now under the CPPA, this is an express provision. So there are certain carve-outs for government institutions under the Federal Privacy Act, and also for personal or domestic, journalistic, artistic, and literary uses of personal information, and for business contact information. But this expanded application reflects the increased digitization and globalization of the economy. Because, as we know, our economy knows no border, and this was only accelerated by the pandemic. However, there are two potentially problematic aspects of this expansion. And this is what David had hinted at earlier. So first of all, there's this issue with the breadth of the application of this proposed law. So section 6.2a provides For greater certainty, this act applies in respect of personal information that is collected, used, or disclosed interprovincially or internationally by an organization. So as you can see, it's not expressly limited to commercial activity in this section. So an argument could be made that it applies to non-commercial or employee information, which would otherwise be beyond the scope of the law, where that information crosses borders. So the second issue is redundancy and duplication. So section 6.2b of the CPPA provides, for greater certainty, this act applies in respect of personal information that is collected, used, or disclosed by an organization within a province to the extent that the organization is not exempt from the application of this act under an order made under paragraph 122(2)b, which deals with substantially similar legislation. So for organizations with operations in Quebec, British Columbia, and in Alberta, which are the only Canadian provinces with provincial general privacy legislation that is substantially similar to PIPEDA, it must now comply not only with the substantially similar provincial privacy laws of those provinces, but also with the CPPA when it moves data from one province to another, which seems redundant. So another possible issue is that the CPPA fails to fill this cross-border gap that currently exists under PIPEDA. So the CPPA doesn't expressly extend to personal information imported into Canada from the European Union under an EU adequacy finding. So under the General Data Protection Regulation, or GDPR, organizations can only export personal data from the EU to countries the EU determines have adequate protections. So an EU adequacy finding still only applies to the extent that the CPPA covers the information, as is currently the case under PIPEDA. So for example, as the CPPA doesn't apply to all employee information, and therefore employee information in Canada would not be protected by adequacy. A clear extension of the CPPA to all personal information that's imported from Europe would have been beneficial to ensure confidence that this adequacy finding from the EU, present and future, would apply across the board. So the next obligation we're going to discuss has to do with new individual rights in the CPPA, and these are data portability and deletion. So data portability is what we'll talk about first. So individuals can require an organization to transfer their data to another organization under this proposed law, subject to regulations that, of course, haven't been drafted yet. So Bill 27, however, this version of the CPPA anyway, it does narrow the data portability provisions compared to that in C11 version, because what it does now is it requires that data portability be connected to a data mobility framework for both organizations. So yeah, both organizations need to be subject to that data mobility framework. Individuals can also require that an organization dispose of the personal information it collected about them, subject to some limitations, in what appears to be a limited form of the right of erasure found in the GDPR. And so that's a deletion. So deletion is described in the CPPA as a right of disposal, and it has arguably been broadened under Bill C27 from what was provided under Bill C11. So in C11, the right of disposal applied to personal information collected from an individual, whereas under Bill C27, the scope includes all personal information that is under an organization's control. So there are certain exceptions to this right of disposal, including where the disposal would have undue adverse impact on the accuracy or integrity of information that is necessary to the ongoing provision of a product or service, or the personal information is scheduled to be disposed of in accordance with a retention policy, and the organization informs the individual of the remaining period of time for which it will be retained. And both of these exceptions apply broadly, except in the case of minors. Note also that personal information of minors is considered to be sensitive information under the CPPA. We're not discussing that in great detail today, though. And so now the final new obligation that I'm going to speak about today is about algorithmic transparency. So as under Bill C11, that version of the CPPA, Bill C27 requires algorithmic transparency. So individuals have a right to require an organization to explain how an automated decision-making system made a prediction, recommendation, or decision about the individual that could have a significant impact on them. Now, significant significant impact has not been defined. The CPPA defines automated decision systems as technology that assists or replaces the judgment of human decision makers through the use of a rules-based system, regression analysis, predictive analysis, machine learning, deep learning, a neural network, or other technique. So the explanation provided by the organization about this use of algorithmic information is that it must indicate the type of personal information that was used to make the prediction, recommendation, or decision, the source of the information, and the reasons or principal factors that led to the prediction, recommendation, or decision. So this is an individual right that's reflected in both Quebec's Bill 64 and also the GDPR, but not in PIPEDA. However, contrary to Bill 64 and the GDPR, the CPPA's automated decision-making provisions do not extend to permitting individuals with the right to object to use or to have the decision reviewed by an employee of the organization. So in other words, it's just a right to understand how your information might be used in this way. And now we're going to move on to the next slide and talk about enforcement.
Excellent. Thank you very much for that, Sarah. So we're going to talk about enforcement now, and this is the headline grabbing element of Bill C-27 and the proposed CPPA, in the same way that C-11 garnered headlines with respect to the significant change in enforcement and possible penalties that organizations can be exposed to as we shift significantly from an ombudsman model into a much more enforcement focused model of privacy regulation in Canada. So probably the most significant difference between PIPEDA and the CPPA, both in its C11 and C27 forms, reflects what many privacy advocates have been calling for, many of whom have been calling for and suggesting that, oh, well, Canada should simply adopt the GDPR and get on with that. But the number one thing that privacy advocates tend to focus on is the availability of significant penalties under the GDPR and the lack of penalties and the lack of order-making powers on the part of the Privacy Commissioner of Canada under PIPEDA that's been under an ombudsman model since it was introduced in 2001. So this is a significant shift. So under the CPPA, the Privacy Commissioner is no longer an ombudsman with a focus on nudging companies towards compliance and solving problems for individuals. It's veered strongly towards enforcement in a much more adversarial regime. And I expect this is going to change the way that organizations and the Privacy Commissioner interact significantly going forward. Under the current model, an individual would complain to the Privacy Commissioner. The Commissioner has an obligation to investigate most complaints. And the focus of that activity is to reach a resolution. And the earlier that resolution can be reached, the better. The Privacy Commissioner wants to close the file and have a positive resolution. The organization wants to have the file closed and have a positive resolution. So you tend to have almost a collaborative approach working with the investigator from the Privacy Commissioner, determining if there was an issue with compliance, what needs to be changed on a going forward basis, how to make those changes in order to get a well-founded, well, you get a not well-founded resolution, but if there was an issue, then it would be well-founded and resolved, the matter would be closed and everybody would move on. We're not going to see, I don't expect, that sort of roundtable collaboration with the Privacy Commissioner when it comes to fixing issues. So under PIPEDA, enforcement starts either with a complaint by an individual or the Commissioner could initiate a complaint. That is the same. But after that point, under the CPPA, things are going to change. There's much more due process and process built into the CPPA compared to PIPEDA. PIPEDA did not talk about procedures needed to be followed. It talked about the powers of the Commissioner in connection with investigations. It didn't bestow upon organizations particular rights with respect to due process and procedural fairness. To their credit, they generally applied common law principles, but there's much more rigor going to be applied under the CPPA. So what happens first is an investigation, and the CPPA sets out more circumstances in which the Commissioner can decline to investigate. So if there are other recourse available to the individual, the Commissioner doesn't actually have to open a file or can refer it to another place. But the commissioner, if the commissioner does have to investigate, the commissioner commences an investigation, and that's the first stage. The second stage, still within the privacy commissioner's office, is an inquiry. And so that's a more formal step after the initial investigation, presumably to determine the merits of the complaint and whether it's worthwhile going to an inquiry, which is the process by which the commissioner will, I guess, adjudicate the particular questions before him and will reach a resolution and perhaps a recommendation for a penalty that I'll talk about in a moment. Now, inquiries have many more procedural protections and fairness and due process than under PIPEDA's ad hoc system, as I mentioned. For example, the CPPA guarantees each party a right to be heard and to be represented by counsel. Now, while in practice this has typically occurred, it will be specifically required under the CPPA. The Privacy Commissioner does have to develop rules of procedure and rules of evidence and make them public and follow them. Up until this point, we don't have any published guidelines for how the Privacy Commissioner conducts an investigation. We do have some insight, and obviously we've been through many investigations, have gotten a sense of the tempo and how these things usually roll out, but there aren't rules that organizations and the Commissioner are expected to abide by. Hopefully that will have reasonable timelines. My experience under PIPEDA has been that the commissioner, when the commissioner asks for information from an organization, that's done with a very short timeline. You send that information back, and it will be months and months and months before you get a reply. So at the end of, and one additional obligation that's slightly different from PIPEDA is that the Privacy Commissioner has to issue a finding within 1 year, which is the same as under PIPEDA, but the commissioner can extend that for another year. Now, also in my experience, I've never seen the Privacy Commissioner, at least in the last 5 years, complete an investigation within that 1 year mandatory timeline. So with published rules of procedure, I expect that things will probably be a little bit more rigorous when it comes to the timetable and the tempo for carrying out investigations and inquiries. So at the end of that inquiry, the commissioner can issue compulsory orders, which are measures that a party must make to comply with the CPPA, or order it to stop doing something that that the commissioners of the view violates the CPPA. Now, under PIPEDA, the commissioner did not have any of those powers. The commissioner could only make recommendations to the organization if they were breached. The commissioner could go to the federal court with the permission of the complainant, and in the federal court under the former procedure, the organization could be ordered to do things to comply or ordered to stop doing things where it was non-compliance. But it was up to the court to determine that, and that was on a completely de novo basis. So this is very different. The Privacy Commissioner issues orders, and those orders become compulsory and can become court orders that can be registered with the Federal Court of Canada and take effect after the elapse of time during which the organization would be able to appeal that order to a new tribunal that I'm going to talk about in just a moment. Notably, the commissioner at the inquiry stage cannot levy any penalties, so cannot award administrative monetary penalties or fines. At that stage, what the commissioner can do is the commissioner can recommend that the tribunal, that I'll talk about in just a moment, will levy particular penalties against the organization. And so it's a very interesting separation of the order-making power from the penalty-giving powers, a very significant change from PIPEDA, and it doesn't follow exactly or track with the administrative monetary penalty regime, which was introduced a number of years ago in Canada's anti-spam law, in which case the CRTC investigates organizations that have been complained about. The CRTC investigators or enforcement branch can levy penalties, and those penalties are mandatory unless they are appealed to the commissioner, to the CRTC itself. This is a different process by which the penalties are being imposed by this additional tribunal that I'll talk about. So this new tribunal is brand new, and so this is why we have multiple parts in the Digital Charter Implementation Act, Bill C-27. So the first one implements the Consumer Privacy Protection Act, and the second part of Bill C-27 implements the Personal Information and Data Protection Tribunal. And so this tribunal, at least as far as private sector privacy law is concerned, essentially replaces the existing role of the Federal Court of Canada. And so it bypasses that. So recourse to the federal court is only going to be available after an individual complainant, for example, has gone through the complaint to the Privacy Commissioner, has gone through the investigation stage, has then gone through the inquiry stage, then into the tribunal. And the tribunal, unlike the federal court, is not a de novo proceeding. Essentially, it has a number of rules. In some cases, it's like an appeal, but where there's a fair amount of deference to the Privacy Commissioner. In other cases, it's a recalibration. So we'll talk about that. So the CPPA will allow organizations accused of violating the CPPA a new right of appeal of the Privacy Commissioner's findings, interim orders, and final orders. So under PIPEDA, only complainants and the Commissioner can seek a hearing in the federal court after the Commissioner has issued their finding. So this expands or gives to the organization that right of appeal that did not exist previously, which in some cases, if you think about it or zoom out a little bit, under PIPEDA, what the Commissioner does is produce a finding. It's not an order, it doesn't compel anybody to do anything, it's just a recommendation. So what is there to appeal? And it's the individual complainant who would go to the court for a remedy if they wanted it. But because inquiries, investigations, inquiries, and now these recommendations are much more significant to an organization, it makes absolute sense that the organization would have the right to have the finding of the Privacy Commissioner reviewed by an independent tribunal for that purpose. Now, unlike the federal court, this is not a de novo hearing. The tribunal's role will be to determine whether any penalties recommended by the Privacy Commissioner are appropriate. It also hears appeals to the Privacy Commissioner's findings, interim and final orders, and decisions not to recommend that any penalties be levied. Now, I can't imagine that an organization will appeal the determination by the Commissioner that a penalty should not be levied, but I can certainly imagine complainants doing that on a regular basis. So unlike the federal court, which is on it right now under PIPEDA, a de novo appeal. So that means it starts with a blank slate. The complainant has to make their case for a violation of the legislation. The responding organization responds with their defense, their position, and although the Privacy Commissioner can be a party, the finding of the Privacy Commissioner under PIPEDA is not determinative. It's not an appeal. It's not an enforcement of that order. The federal court starts from scratch with a blank canvas. That's not the case now. So with the tribunal, in contrast, the tribunal will review the Commissioner's decision under a much stricter standard and a much higher level of deference. It's going to be correctness for questions of law and palpable and overriding error for questions of fact or questions of mixed law and fact. And practically, this means that while organizations that collect, use, or disclose personal information will now have an opportunity to appeal the Commissioner's decision, which is great, that appeal will be subject to a stricter standard of review, which is harder for the organizations. The tribunal's decisions themselves are going to be subject to limited judicial review before the federal court, so not an appeal and not a rehearing of any of these. And unlike Bill C-11, and one thing that I think is important, and I'm going to talk a little bit about what I anticipate the timing to be on the implementation of the CPPA. The concept of the tribunal was introduced under Bill C-11. One thing that was the subject of criticism was under Bill C-11, there was a requirement that there be a minimum of 3 tribunal members, but only one of them had to have privacy expertise. Under Bill C-27, there has to be a minimum of 3 tribunal members, including 1 chair. All 3 of them have to have expertise in privacy. Now, or a minimum of 3. So for example, if 5 are appointed, 3 of them have to have privacy expertise. And while the tribunal's jurisdiction, at least under the CPPA and the Digital Charter Implementation Act, is currently limited to hearing matters referred to or following an inquiry by the Privacy Commissioner, we fully expect that the role of this tribunal is going to be expanded. So for example, just immediately prior to the last election, the Government of Canada did a consultation on proposals related to dealing with online harms. And that proposal, it wasn't a bill, it was just a proposal for discussion, but it really looked like the beginnings of a draft bill. Those have been put, I think, a little bit on the back burner, but what was particularly notable about that proposal is it actually did foresee a role of this particular tribunal in determining matters related to online harms. So I would not be surprised at all over the life of the tribunal to see it being given more and more duties and more jurisdiction with respect to digital matters. I mentioned previously at the beginning, Part 3 of the Digital Charter Implementation Act of 2022 includes this artificial intelligence bill in particular. It doesn't use this tribunal. It allows the minister in the federal cabinet to set up a commissioner, and that commissioner is essentially a deputy minister. Why it doesn't use the privacy commissioner or why it doesn't use the tribunal, I'm not sure. It will be interesting to see how the government frames that particular proposal and talks about why they went in a different way. So when it comes to the enforcement, things are very different procedurally, mechanically into this tribunal instead of the federal court. But really the big attention getter is the significant penalties. So there are large consequences. Right now under PIPEDA, the worst outcome is the privacy commissioner can name and shame an organization. Now that's not to say that can't have significant consequences, because it really can. And most organizations are really keen to stay out of the headlines and to avoid a situation where they've been found to be non-compliant by the privacy commissioner, particularly where there's no appeal of that. There's no rehearing of that that's available to the organization. The organization could be taken to court by the individual or by the individual and the privacy commissioner together. There could be an order, but there's no significant penalty. The individual can seek damages, but only on an individual basis, and those damages tend to be modest. And so that model, I think, has worked largely for many large organizations that really do have concern about that sort of exposure. But privacy advocates over the last number of years have been chomping at the bit and trying to get Canada to follow the GDPR. And really, this Bill C-27 and the CPPA is doing that in a significant sort of way. So we have two categories of penalties. We have administrative monetary penalties, and then we have fines. And the same actions, same activities could give rise to both, but it's worth listing what is within the AMP purview and what is exclusively within the fines purview, and what is that, where's the overlap. So the 2022 version of the CPPA authorizes a maximum administrative monetary penalty in one case. And so it could be a series of defaults, but in terms of on one file, let's say, to the higher of $10 million and 3% of the organization's gross global revenue in the financial year previous to the year in which the penalty is imposed. And so the first version of the CPPA would have authorized AMP's administrative monetary penalties of up to $25 million or 5% of global revenue, whichever is higher. And currently, PIPEDA only authorizes limited violations of the Digital Privacy Act's data breach response obligations, and those are markedly lower. But you'll notice these numbers are on par with, in the same league as the GDPR's possible penalties. So these, if you're a global company with significant revenues, and we have to recognize that Canada is a relatively small player in the entire global economy. Our population is about the size of California. Our economy is about the same size as California. But in the global sense of things, Canada is a bit of a drop in the bucket. But if you're a global organization, what this means is that your global revenues are potentially exposed. Now, there always will be, hopefully, a sense of proportionality. One thing that we have also seen under Canada's anti-spam law is that when significant penalties have been imposed by the enforcement branch of the CRTC, those limited matters that have gone up to the commissioners, up to the full commission, have tended to be scaled back in a significant sort of way. It will be fascinating to see how this plays out on a matter going forward. So those are the administrative monetary penalties. We also have quasi-criminal prosecutions. So the CPPA allows for fines that carry even higher financial consequences than the $10 million or 3% of global revenue. So a Crown prosecutor can decide whether to proceed either by way of an indictable offense, with a fine not exceeding the higher of $25 million and 5% of the organization's gross global revenue, or a summary offense where the numbers are $20 million and 4% of the organization's gross global revenue. Now, if there is a prosecution for these quasi-criminal prosecutions, that should impose the same sort of procedural safeguards and procedures and fairness that are currently existing in regulatory enforcement penalty actions that are not administrative monetary penalties, but are criminal or quasi-criminal. What that also means is in the administrative monetary penalty regime, the burden of proof on the commissioner or the complainant is going to be a balance of probabilities. More likely than not, 50% plus one that the organization was non-compliant with the legislation. Under these quasi-criminal prosecutions, the burden should be proof beyond a reasonable doubt with a presumption of innocence, and charter rights are going to be more applicable. I don't expect we're going to see many of these. It will only be in egregious circumstances that I imagine that will happen. Also, the privacy commissioner, at least under the bill as I read it, doesn't become the prosecutor in these. It has to be referred to the Federal Prosecution Service. And we've seen in other provinces where there are offenses in privacy legislation, at least initially, a lack of interest or enthusiasm by the Crown Prosecution Service to take over these files and prosecute them like other matters. We also have, similar to PIPEDA, a statutory right of action. So under PIPEDA, the individual goes to the Privacy Commissioner, complains to the Commissioner, gets a finding, and they can go to the court, and it's a de novo hearing. And among the remedies the court can order are any damages that the individual might be entitled to, using general principles of damages, but it can also say specifically for any embarrassment or humiliation the individual may have suffered. The CPPA is actually similar to that. So an individual, after having gone through the process, and they have to go through this multi-stage process in order to then go and seek damages. So this creates a new privacy breach legal claim that is specifically connected to a violation of the CPPA. We have common law claims for damages under privacy, intrusion upon seclusion, public disclosure of private facts. That's under the common law. Some provinces have statutory torts related to invasion of privacy. A non-compliance with PIPEDA may be evidence of not living up to the standard of care, but those aren't statutory where you're able to get damages because somebody did not follow their legal obligations under this particular statute. This changes that a little bit. So if an individual ends up with a finding from the commissioner, from the tribunal, that there was a lack of compliance, they are able to seek damages. So the individual can sue the organization within 2 years of the commissioner's finding for compensation where the privacy commissioner decides the organization violated the individual's privacy under the CPPA and the tribunal upholds that finding. So while PIPEDA limits any action to recover compensation for a violation of privacy to the federal court, the CPPA will also allow aggrieved individuals to file such actions in the superior court of a province. However, the wording of the CPPA makes it unclear whether a violator is also exposed to class action liability. While PIPEDA limits the ability to seek compensation for a violation from the court system to a complainant, so the person who or the people who complained specifically to the privacy commissioner, the CPPA broadens this to an individual who is affected by a violation. So that may mean that if there's a data breach, for example, and 5,000 consumers are affected, only one complains, those 5,000 may be able, if they're similarly affected, they may be able to pursue this course of action. I'm not sure that exposes organizations to significantly more risk than we already see under existing privacy class actions that have exploded in the last number of years since the Jones and Siggy case from the Ontario Court of Appeal significantly opened the door for privacy class action claims under the common law, and I think whetted the appetite for class action lawyers to look at these new forms of claim. So it's different, procedurally different. It's interesting that it will potentially involve the superior courts of provinces. I don't know exactly why that was done. Keeping that within the federal court would be consistent with having a tribunal, which is the specialized decision maker on privacy, and building within the federal court specialized expertise with respect to these particular kinds of actions. It does mean that procedural rules from province to province might provide opportunities for forum shopping, might also end up with overlapping. So if you had two complainants, one from Ontario and one from Nova Scotia, one could start an action in the Ontario Superior Court of Justice, and another one could start an identical action in the Nova Scotia Supreme Court, both of which relate to the exact same facts, involve the exact same respondent, would be duplicative and potentially problematic. But anyway, we'll see if organizations will make submissions to the government on that particular aspect of it, and whether or not the government would be interested in changing that. So with that as the background, let's talk about what we should be doing now, and let's try to look a little bit over the horizon. So the bill was introduced in Parliament in June, so last month. I don't expect, so even if the government were to fast track it, were to put it through committee, second reading committee, third reading over to the Senate and out before the Christmas break, which is possible, but I think not necessarily likely, because there will be a long lineup of organizations and individuals and advocacy groups looking to make submissions on this bill in committee. Even if that were to happen, I don't anticipate that this legislation, the CPPA and the Tribunal Act, would actually come into effect for quite some time. And the reason for that is that in order for the CPPA to come into effect and the Tribunal Act to come into effect, there would have to be a tribunal, which will involve Ottawa hiring the commissioners or the tribunal members, setting up an office, entering into contracts, buying photocopiers, office space, all those other sorts of things that are just part and parcel of setting up a new bureaucracy or institution in the National Capital Region. And I can't foresee that happening very quickly. Even if the government is currently interviewing, which I don't know whether they're interviewing potential tribunal members, even, well, I imagine they already have an excess of office space in Ottawa and Gatineau, so that might not be an issue. But you know, they'd have to come up with rules of procedure, all these other sorts of things. I don't anticipate that could take place within the space of less than a year and a half or 2 years. So this means we likely have some time, and of course, there's a possibility that we'll die on the order paper. There's speculation about a fall election. Now, I think that's largely made up. But you know, so this has not been passed. This has not been proclaimed. This is not yet in force. And as I said, as I speculated, probably won't be enforced for another 2 years. So is there anything to do about it now? And I think that there probably are. One thing, if you're an organization that has been focused on PIPEDA compliance for some time, probably when you read the CPPA, you think, well, you know, the CPPA isn't radically different. The Canadian Standards Association Model Code is no longer there, but it's codified in the statute, similar to what exists in the Personal Information Protection Acts of BC and Alberta. All of the principles from the CSA Model Code are baked into the CPPA. And what it largely does is it turns those up from, let's say, 4, not to 11, maybe to 7. And so it prescribes in greater detail the rigor with which an organization has to turn their mind to and document procedures, policies, and practices related to personal information. So if an organization wants to get a head start on all of these things, it really would make a lot of sense, at least in my view, to do these 5 things. Do a full data inventory. Understand what data you have, where it is, who has it, who controls it. Is it with a service provider, or do you have it in-house? Do you have it in-house? Is it hosted someplace else? Is it on a server with blinking lights in your organization? Is it in filing cabinets around? Understand what information you have, and then analyze why do you have it. So as Sarah said, an organization has to document all of the, now that's already in PIPEDA, but I don't think many organizations have done it because it's in the standard. Now it's in the statute, or will be in the statute. An organization has to document all of the purposes for which it collects, uses, or discloses personal information. For all of those purposes, it will have to go through that risk analysis. It makes a lot of sense to do that now and get a head start on implementing those obligations. Take a look at your privacy management program from beginning to end. Look at the obligations in the legislation. it requires a mature privacy management program. And think about what your issues would be or your concerns would be if the privacy commissioner were to go knocking on your door right now and say, please give me all of the documentation related to your privacy management program. Because once this legislation is enforced, the commissioner is going to have that power and can ask for that information. And certainly I've seen in connection with investigations under PIPEDA, where among the first asks of the investigator is for all of this sort of documentation to understand the organization's privacy posture and maturity. So get a jump start on that and get an understanding of where your gaps are and make sure those are adequately done. Privacy notices have new obligations or will have new obligations under the CPPA, and particularly are required to be in plain language. So it makes sense to look at your privacy statements, your public-facing privacy statements or privacy policies, and review them for plain language, review them for compliance with current PIPEDA, but also look over the horizon and determine whether or not you include in your privacy statements the information that's required by the CPPA. And then review your service provider agreements. If you're an organization and you outsource any processing or storage of personal information, you're going to want to make sure that those agreements are in shape. One of the things that I've been doing on a regular basis for some time is in standard contracts, make sure there is a provision that requires a renegotiation or a recalibration of the agreement in the event of a change in the law. Privacy law in Quebec has changed significantly and will continue to change over the phase-in period of Bill C-64. What is in the CPPA might change by the time it becomes law, and you're going to want to make sure that you have an understanding with your service providers, or if you are a service provider providing services to your customers, that certain things might need to be recalibrated, and you can limit the negotiations to those things rather than reopening agreements entirely. So those are 5 things that you can start doing right now, just in anticipation. Even if the CPPA and Bill C-27 were to fall off the order paper and disappear, you would find yourself managing privacy risk in a much better way if you spent the next little while doing those things. And so we do have saved a little bit of time for questions. I see 6 minutes left, and we welcome any questions. I think we've probably touched on all of the questions that were provided in advance related to the legislation, its scope, or the bill, its scope, when it's expected to come in, how it will apply to employee information. So we have a question, the exceptions to consent for a financial institution, does that mean that when we collect personal information for providing a product or service, does that mean we don't need express consent from the client? So it could fall within one of the 2 consent exceptions, the business purposes or the legitimate interest purpose. I think that certainly more organizations are going to be relying on, which those don't exist under PIPEDA. So I think many organizations will be implementing those consent exceptions. But I would be very careful, and this is one of the benefits of doing an analysis of what information you have, how you use it, and where does it fit within these. A complicated financial institution is probably using personal information in ways that an individual perhaps might not expect. And so whether or not, if they don't expect that use, then it doesn't fit within that particular exception. And there may be secondary uses that information is put. And for financial institutions, the information is probably sensitive information from the get-go. So I would not start with the assumption that, hooray, we can use these consent exceptions going forward. I would probably want to make sure that if you can comply or if you can use those exceptions, you're exactly within the 4 corners of them, and there's no particular risk. I might, if I were a risk-averse organization, which many financial institutions are, but not all, would look to see how this plays out, and wait to see if there's some guidance from the privacy commissioner. The commissioner is not going to be able to make binding pronouncements of the law, but you'll get a sense of what way the wind is blowing with respect to the implementation of these exceptions. the financial sector might be interested in putting together codes of practice where different organizations can collaborate. Say, look, here's our industry standard for using information in this particular way that might provide more latitude. So second question, is there a timeline for the retention disposal of employee personal data after they leave the company? So under PIPEDA, that employee information is only subject to PIPEDA if the organization is a federal work undertaking or business, or if the individual employee is a resident of Quebec, British Columbia, or Alberta. And those rules generally require that you only retain personal information for as long as necessary for the purposes for which it was collected. The CPPA, interestingly, will require an organization to retain information that's been used to make a decision about somebody for a reasonable amount of time so that they can exercise some recourse. What that might mean, actually, if somebody applies for a job and they don't get it, or somebody applies for a job and they're interviewed and they don't get it, there may be a requirement in order to retain the notes, the interview conclusions, things like that, the scoring of the candidate, and provide them with an opportunity to review it. So one benefit of reviewing all your information holdings and the purposes is because retention is connected to the purposes. There's some information, for example, in an employee file that you might want to keep for a very long time. The employee's name, their role with so let's say somebody leaves your employment, you're going to want a record that you employed them. You're going to want to keep the ROE and the supporting documentation for as long as the Employment Insurance Commission, it might be relevant for that. You're going to want to keep the payroll information for as long as you need to, related to at least 7 years, according to CRA, Canada Revenue Agency guidance. So different bits of information may be required to be retained for different amounts of time, but some things may be almost immediately disposable once the employee has left the company. So that's one of the benefits of doing that inventory and recognizing purposes, because coming out of that and related to the privacy management program is going to be calibrating your retention requirements for all of that information. And the same lens would be applied to customer information, because the exact same principles are going to be applicable. I don't know if we have a last question. Will this affect the use of general release forms? Will they have to be more specific? So when you document consent, when you get somebody's written consent for something, it's pretty clear that the individual under the CPPA and also under the way that the commissioner has been thinking more recently, is that the individual has to understand what they're consenting to. And the individual has more choices with respect to what they consent to. And so I would say, as part of the preparation for this, but perhaps not finalizing it, is that, yeah, if you have a very general, very broad consent, it's probably not going to be compliant. It's probably not compliant currently. One of the first findings issued by the Privacy Commissioner of Canada when PIPEDA came into effect in the early 2000s related to a consent that said, oh, we will use your personal information for this, that, and the other purpose, oh, and for any other purpose. And the commissioner said, you know, that's too broad. An individual doesn't understand what it is that they're consenting to, and that's not adequate. But I do think that all consent forms and releases will need to be revisited. So yeah, I think we're slightly over time, just by 1 minute, and I want to be very respectful of your time. Thank you very much to everybody who joined us today. Hopefully this was useful. Although I can't tell you exactly what the final bill is going to look like. Hopefully it's given you a good understanding of what it was that we can anticipate in relatively broad strokes and steps that you can take in the meantime. If you'd like to be, if you're not already signed up to receive updates and alerts from McInnes Cooper related to legal developments, please subscribe. There's information on the screen there about how to do that and a QR code. Thank you all very much. Of course, if any of you require any assistance with planning for this, Sarah and I are easy to find, and we're more than happy to help and advise clients. We've already been working with a number of them who are looking forward to, or perhaps dreading in different ways. Anticipating is probably a better way of talking about it. Anticipating the changes that the CCPA are going to bring about. So anyway, so thank you all very much for attending, and we're grateful for your time. Cheers.
Thank you.